Yesterday, we discussed various acts, including the Biological Diversity Act. And uh, now there is one more point that needs to be added. That is, uh, actually, we discussed various forms of intellectual property rights, including the uh, copyrights, then trademarks, designs, patents, and various geographical indications and traditional knowledge, etc. But the choice of IPR, what form of protection that you need for your uh, invention or your intellectual property, that needs to be decided based on some factors. For example, for a script, the only possibility is a copyright. And if you have a new invention, for example, a new formula like the Coca-Cola or some other secret ingredient that you have, that you develop, then in that case, if the pace of technology development is so rapid, then trade secret is preferable, because you are disclosing your entire technology based on behind that invention for the public for further development. In the previous example that we discussed, for example, you invent a 4x digital zoom of the camera. Now, as you know, in the case of a mobile phone technology, the capacity of the camera, digital zoom capacity, or the resolution of the camera, it increases, or better and better resolution were introduced within 6 months or something. So previously you have a few MB 4 or 5 MB camera is there, but now we have 108 MB camera in mobile itself, which is available. So that means the pace of technology development in that area is much higher. So if you are introducing a new technology for a, say 48 megapixel camera, within 6 months, next 6 months or 12 months, maybe a better camera with a better resolution, maybe double the resolution that you introduced, will be developed by somebody else who used the base of your technology. So that means with the rapidly developed technology, you can't keep up your technology in the market. So naturally, if a new invention based on your invention is already introduced, your technology will be washed out of the market. And in that case, if you want to keep your protection for time, then the only option you is before you is keeping it as a trade secret without disclosing to others, so that others can further develop a better technology based on your technology. But the main problem is that it is against science, or it's against technology progress, because a trade secret cannot be shared and it cannot be further enhanced by other people. Whereas in case of the patents, what happens is that you are disclosing your entire content and knowledge to the community, so that anybody interested can keep on developing that technology for a further contribution to the science. So in this case, as you know, if the technology changes rapidly so that you can't keep your protection, or the relevance of your protection or the property becomes irrelevant after a short period of time, then it is better not to disclose that secret in the form of a patent and keep it as a trade secret. And trade secret, actually, it is a maintenance is costly, whereas enforcing patent is costly. Because for the enforcement of the patent, you need to pay for the patent renewal every year. Renewal fees is there every year. You have to pay the fees for that. Procuring patent through a laborious process. Maybe there is a long process of patent application and scrutiny and other things. It may take years for granting you a patent. And that type of establishing and enforcing, and even the legal rights of the patent, if somebody violates your invention or your property, then certainly you have to go to the court for enforcing that one. So that part of getting a patent, maintaining a patent, and even enforcing that under the law is a costlier effort. Whereas maintenance of a trade secret is a costly affair, because you have to use your own measures for the protection of the secret. You can't involve a lot of people in that one. And for example, if you are developing a new microbe, you can even the same microbe that you are using secretly in your lab can be obtained from your drainage. So if somebody collects the drainage and tries to isolate the same microbe, then certainly your trade secret will be out. So in that case, especially for the microorganisms and other things, the technology which is based on microbes, microbe cannot be kept as a trade secret without decontaminating the entire effluents which is coming out of your lab and keeping all other personals out of reach of the concerned item. So that maintenance part of the trade secret is a costly effort, whereas enforcing and obtaining an patent is also a costly effort. And you have to keep a balance between that. You have to think about up to how much duration this technology is actually protected, and you will get financial benefit out of that. Whether it will be washed out of the market immediately, all these things needs to be considered while selecting between a patent or a trade secret. Means you want to whether you want to disclose your technology or not. So that is it. And obtaining plant breeders' rights is cheaper than patent. For protection of the plant varieties, for the farmers or the developers of or breeders of the concerned plant varieties, then it is quite cheaper than you are comparing the obtaining and or enforcing and obtaining of the patent. So if you have a plant variety, it's better to get PBR rights, not the patents. Then, in long term or long run, the maintenance of the trade secret is difficult and costly. Already it's mentioned. The patents can be shown to the investors for commercialization without fear or theft. So once you disclose everything and it is in the public domain, then there is no fear of theft because it's already open. And whoever uses the technology, you can claim your licensing fee or whatever financial benefits that you require, you can claim from them legally. Because everything is disclosed, then there is no fear of theft in the case of patents. Hello? Patents offer protection for a limited period, means about 20 years. Currently, it is 20 years, and PBR is available for 25 years. And trade secrets were available for longer periods or for indefinite time or until you keep it as a secret. It is available. So you have to choose which option is better for you to protect your invention or idea or process or whatever that you develop. And that can be in the form of IP applicable to your invention or your technology needs to be decided on all these various factors. We'll see the patentability of life forms in India, or we will discuss the status of the patentability of the life forms worldwide. In TRIPS agreement, that is a trade-related aspects of intellectual property rights. That is a TRIPS agreement. There is a section in the Article 27(3)(b) subsection. And that actually explains, or Article 27 of TRIPS agreement between the nations, actually, it explains the patentability of the microorganisms. Means what can be patented and what cannot be. So that is done in case, or that is explained in the case of Article 27 of the TRIPS agreement. And here, Article 27(3)(b), that's the subsection of the TRIPS agreement, that explains something like the members means member countries may exclude patentability inventions. Some can be excluded from patents by the member nations. Because TRIPS agreement is usually it is enforced between the member countries, and the countries are actually bound to implement the terms of the TRIPS agreement worldwide. So after signing the TRIPS agreement, even India was bound to after signing, bound to implement or make our own amendments in the law or make our own laws for protecting the different forms of the IPR. And Article 27.3 B, it provides some provisions for the member nations to exclude some items from patentability. And the prevention within their territory means of a commercial exploitation of what is exempted. It is the prevention of prevention within their territory of commercial exploitation of which is necessary to protect public order. Order public means it is a public order. So if something needs to be prevented or some patentability needs to be prevented in their territory or in their nation or from commercial exploitation to protect what? Public interest, public morality, including to protect human life, animal or plant life, or health, or to avoid serious prejudice to the environment. So if something is hazardous to the environment, or something is adversely affecting the human, animal, or plant life, or if it is affecting the general public order or morality, then that types of inventions or technologies need not be given any patent in the country. So that provision of Article 27.3b of the TRIPS agreement allows the member countries to exempt some items from patentability. So that's the law. And there is another segment which explains diagnostic, therapeutic, and surgical methods for treatment of humans and animals may be exempted from patentability because it is considered as a life-saving measure. Then another section, that is plants and animals other than microorganisms and essentially biological processes for the production of plants and animals other than non-biological and microbiological process. So this needs to be exempted. For example, you cannot patent a plant, you cannot patent an entire animal other than microorganisms, a life form. Generally, in the case of life forms, plants and animals were exempted from patent other than except microorganisms. Okay, and essentially biological process for the production of plants and animals. If you are trying to clone something, then that is prevented. Or animal or a human, if you're trying to clone that one, and after that you can claim that okay, this is my invention or my product that I created. So you cannot follow a biological process for the production of animals and plants other than microorganisms. So that type of technology or inventions which actually owns a microbe, owns an animal or a plant, or create an animal or a process or biological process that creates an animal or plant is actually exempted from or excluded from the patentability. So that's about Article 23b of the TRIPS agreement. So this gives the nations to exclude many items from patentable list, like if it is affecting their public order, morality, or if it is affecting the human, animal, or plant life, or if it is causing some serious injury to the environment. All these types of technology or inventions can be prevented, or it can be excluded from patentability under this section of the TRIPS agreement. And it also exclude diagnostic, therapeutic, surgical methods for treatment of animals and humans, and also it prevents the patentability of plants and animals other than microorganisms. So this is a summary of that section. And on detailed analysis of this 27.3b, we can see that we can exclude plants and animals and essential biological processes which creates plants and animals. So that's excluded, and must allow patents for microorganisms and biological processes. That's a significant part. If you are asked about patentability of a life form, then it can be done because microbiological processes and microorganisms can be patented. no other life forms. So there is an exemption in that. That is the case of microorganisms. Must provide protection for plant varieties. So there is another segment in that one, that is it provides protection for plant varieties using PBR. Is not patent. Plant varieties can be protected. A newly developed plant varieties can be protected using plant breeders' rights and such acts. Okay. So here, the criteria of novelty for patenting for microorganisms. So when we are discussing that that item, that's anyway, novelty is a criteria for patenting. For patenting everything, any invention, if you want to patent, then novelty is the basic criteria. So if you are address the question, is the discovery of a microorganism from nature for the first time is an inventive step? Is it novel? So you have to say that it is not an invention. It's only a discovery, right? It is not. Means a microorganism exists in nature as part of the nature, and if you are screening out from the soil or from the environment, it's only a discovery. It's not a novel invention with a novelty. If it is an invention, logic of treating scientific theories and principles as non-patentable inventions gets defeated. And also, if the microorganisms isolated from nature for the first time are considered patentable, then minerals, ores, or whatever items which is discovered from nature for the first time, from the interior of the earth or deep sea, everything will qualify for patenting. And that is not allowed because it is considered as a natural resource already existing and not a novel or new creation. It's only a discovery. So thus, microorganisms can be considered as invention only if the microorganism has not described in the literature. It is not described in the literature. It should be new. That knowledge about the microorganism should be new. And there is an element of human intervention in the discovery. Then in that case, the microorganisms are permitted to get a patent. Otherwise, the normal microorganisms that you are isolating from the environment were not patentable because it's only a part of the nature. And if it is not already known, the organism is not already known and described in the literature, and also if you are manipulating the genome of the organism to create something new, it is not a naturally existing one. Then if there is a new invention, human intervention in the discovery of that organism, then that type of microorganisms can be considered as an invention and not the naturally existing ones. So this is the concept. Patent on Streptomyces violaceus, a microorganism accessed from the soil in Hyderabad, India, granted a US patent in 1991 and to Bristol Mayer, that is the inventor. And it would not be a valid patent because it is only a microbe that actually it was in 1991 that such a patent was awarded in US for Bristol Mayer. But it is actually a discovery from Hyderabad. It's already an actually existing one. So in that case, if that got challenged and the patent becomes invalid. So a naturally existing organism, if it is already got a patent, then during the later challenges, that patent will become invalid. So that's about some of the microorganisms which are already existing in nature. But when we come to some other items, first patent based on microorganism. This is not a microorganism, entirely microorganism. This is a patent in 1873 for Louis Pasteur. There's a US patent. As we mentioned, even in late 17th century itself, there is a have these patent technology or patent idea is available in US and other countries. And this is about the patent of Louis Pasteur, and that's for improvement in the manufacture of beer and yeast. That is actually it's something like a patent using a yeast, but it is not actually a patent of the yeast. So it's a technology or it's a process which is having some application of a microorganism. That's a first patent based on micro. It's not patent on microorganism. It's a patent based on microorganism for the process. But then comes the case of Diamond versus Chakravarti in ways. In this case, actually, there is an engineer, genetic engineer known as Ananda Mohan Chakravarti. He was working for the General Electric, developed a bacterium derived from the Pseudomonas genus, now known as Pseudomonas putida. And this organism, now known as superbug, it is known to break down the crude oil, which can be used for treating the oil spills in the sea. So that putida, Pseudomonas putida, actually, once actually it is genetically engineered and it's invented, then the General Electric company or the institute in which he was working for, and they filed a patent application for the bacterium in the United States, listing Chakravarti as the inventor. But the application was rejected by the patent examiner because under the patent law at that time, living things were generally understood to be non-patentable, and it's a subject matter under the section 101 of the title. That's the title of that patent act in the US at that time. So anyway, at that time, when they filed the patent, the General Electric company, actually, when they filed the patent for the inventor Chakravarti, it was rejected because patentability of microorganisms was not there in US at the time. Then they go for an appeal, and the Board of Patent Appeals then and in interferences, actually, they agreed with the original decision. Means again, the patent was denied by the Board of Patent Appeals. However, the United States Court of Customs and Patent Appeals, that's an actual court, and courts, when they moved to the court, they overturned the case of in Chakravarti's favor, writing that the fact that microorganisms are alive is without legal significance for purpose of patent law. So if you are using microorganism for the production, or if you are even the product itself contains a micro, for example, curd, it contains a micro, and different probiotics, it contains microbes. So the fact that the microorganisms are alive is without significance for the purpose of patent law. So that was the verdict by the US court. So means Sidney A. Diamond, the Commission of the Patents and Trademarks, appealed in the Supreme Court. So that's the Diamond. Actually, Sidney A. Diamond is the Commission of the Patent Trademarks who denied patent to Chakravarti. But again, there's appeal in the Supreme Court, and again, Supreme Court gave a verdict in favor of Chakravarti, and finally, the patent was granted on March 31, 1981. So that was a main turning point in the patentability of the microorganisms. Until that time, a microorganism, none of the living things can be patented. But based on these verdicts from the US Supreme Court, microorganisms and the products which is developed on the basis of microorganisms were made a subject of a subject eligible for a patent. Okay. This is the case. Then another case that is in India. In 2002, there is a case that, like the Diminiaco and AG and case, and that is a landmark decision for India. Here, Diminiaco AG, a Swiss company, and they are the applicant for the patent, and they have a process for the preparation of live vaccine of bursitis. And this live vaccine, actually, it contains some living microorganisms. And the patent office, actually, Indian Patent Office, in 2002, they rejected with the reason that a statutory definition of manufacture did not include the process resulting in a living microorganism. So actually, the patent is for manufacture of a live vaccine, which involves a live microorganism. So the manufacture of a living organism is not justified at that time. So the patent office rejected that you cannot manufacture a living microorganism. So that was the case. And the Calcutta High Court considered this case, and we can see that in the absence of a definition in normal dictionary meaning of these words should be accepted. If it is not defined in the law, manufacture and it doesn't include living things. If that statement is not included in the normal dictionary term, so the normal dictionary term should be considered. And in that case, no statutory bar in the act to accept a manner of manufacture as a patentable, even if the end product contains a microorganism. That was the verdict. So even if the end product contains a microorganism, it's a manufacture process. So that was the ruling of the court, and directed the patent office to reconsider the patent in the light of the court observation. And finally, that live vaccine, which actually included that live vaccine or a live organism, which is a part of the live vaccine, was patented. And finally, patent was granted with the patent number, which is shown there, 1,87,970. So that was the patent number. So this was two cases, and that is the first case, not noticeable case in case of US. That is a Chakravarti case, and in India, this vaccine case is there, and which is actually which sanctioned a patent from the Calcutta High Court. And then comes the Budapest Treaty, and you can see that various courts or the decision or the verdicts of the court were in favor of such a inventions in which involve microorganisms. So in case of Budapest Treaty, there is a treaty between the nations, and they have a union for the international recognition for the deposit of microorganisms. Once the patentability of the microorganisms were generally accepted worldwide based on all these events, then there should be some regulatory ways for controlling these patents. So which requires repositories for the deposition of such a patentable microorganism. And this Budapest Treaty, it's a union for national recognition of the deposit of the microorganisms, signed in Budapest in Hungary in 1977, and it is also administered by WIPO, that is the World Intellectual Property Organization. Then India became a signatory from 2001, and the purpose of this treaty is to enforce sufficiency in the disclosure of the biological material. For example, you invent a novel bacteria which is having some particular deficiency. Or you invent means you have already some bacteria, and you, by genetic manipulation or something, you maybe you will make it glow, or you make it to produce something, some useful item. Anyway, you have your own specifically designed bacteria that you want to patent. So what you need to do is for every patent, you need to disclose it and make it available to the public, right? So for the since the bacteria is a product that is in your hand, that then you need to submit that bacteria to a repository. If means the documents can be published so that everybody can access. But for a bacteria, since it's a live form or live culture, that needs to be submitted in a repository, national or recognized worldwide recognized repository, so that everybody can access the same strain if it is required. Otherwise, after one or two steps of sharing, maybe after repeated subculturing, the organism may change. So the original invented organism may not be available after a few subculturing or after transfer from lab to lab. So in that case, the originally patented material needs to be protected as such in such a standard repositories for a long term, so that anybody can use it as a reference material. So that is concept of the International Depository Authorities, or IDA, which is which came to force, or which is established after the Budapest Treaty in 1977. In India, we have various culture collections are there, but IDA, or International Depository Authority, which is accepted worldwide, is two. That is a Microbial culture collection, MCC, that is a one. I think that was in Pune University or something, MCC. And another one is a MTCC, which is in Chandigarh or IMTech Chandigarh. These are the two internationally accepted depositories. So if you have something to be patented, some organism, microorganism to be patented, you need to initially submit, characterize the organism, write all the technical requirements about the culture of the organism and maintenance of the organism, and all the administrative requirements, all the procedures needs to be filled, and finally submit the organism into such an international depository authority in your name. Then you can go for a patent. Because patent office and even further scientific community needs to validate. If they want to validate, they need a standard reference strain, or your strain should be submitted in the repository so that it can be referred in future. So in India, this MTCC, that is a Microbial Type Culture Collection Center of the IMTech Chandigarh, and MCC, that is Microbial Culture Collection, is, I think, is in National Center for Cell Sciences or something in Pune University, and they maintain that one. So we have two different international depositories, but there are various institutes in which different forms of bacteria or fungi, etc., were kept. Maybe scores of them, means but they are not accepted as an international repository. But in India, IDA or International Depository Authority in India is MCC and MTCC. And the types of organisms that is deposited in that repository includes bacteria, pathogenic and non-pathogenic, fungi, plasmids, yeast. All these things were submitted in the repositories and maintained for a long time for a reference. So this is the IDA. And then the non-patentables in biotechnology, when we are considering the non-patentables in biotechnology, this is the Indian status. Under the patent laws, we have the section 3B, the inventions contrary to the public morality is prevented. Because when we discussed the Article 27(3)(b), it gave the right to the nations, individual member countries, the right to prevent or prevent patentable subjects under that section. So in India, the section 3B of the Patent Act actually it prevents the invention of inventions contrary to public morality. And then at 3C, then it became the discoveries or things isolated from nature, plants and animals which are already existing in nature were excluded from patentability. Then Article 3D, new forms or uses of a known substance. If the substance is already known, already existing in nature, and you just discover some new form, then it's only a reinvention which is already existing in nature. So that is excluded from patentable list. Then a mere cocktail or admixture, a cocktail of something, it is also a non-patentable item. Then method, treatment and diagnosis. Then agriculture or horticultural methods. Then traditional knowledge which is already existing in the community for decades or for centuries, and that traditional knowledge. Just like that, yesterday we mentioned the tribal community may have their own traditional knowledge and or even Ayurvedic medicines. All these were part of our traditional knowledge, and one cannot get a patent for such articles. So these are the list of the articles, that is section 3B to P, and these items were actually excluded from patentability list in India. Then in biotechnology, we have some items listed like non-patentable items, living entities of natural origin, like plants, animals, and other things, except microorganisms were exempted. Then any process of manufacture or production of living entities, cloning, for example, transgenic plants and animals, then biological materials such as organs, tissues, cells, viruses, and processes of preparing them, gene sequences, DNA sequences without disclosed function. If the DNA sequence that you are going to patent, if it is having a specific function, then it can be sequenced, or it can be patented, because the function of the entire function of that gene is already discovered by you and it is defined. But without that, if you are getting, for example, you go for an entire whole genome sequencing of an organism which is not sequenced, and then you get a patent and prevent others from using the entire gene sequence, even without knowing the function of that sequence, then that is not possible. So if you know the function of the gene, and you exactly if you define the function and role, then that type of DNA sequences with non-functions were patentable, but not the entire raw DNA sequences. Then the essentially the biological process for the production of plants and animals, that is exempted. Then any biological materials or methods causing serious prejudice to the human, plant life, environmental health, we already discussed when we discussed that Article 27BA. And here, such processes which is having some serious environmental or health implications, or something which is against the public morale, everything is actually non-patentable. And the process of cloning human beings or animals, that is also non-patentable item in India. Then what we can patent in biotechnology: recombinant DNA, plasmids, process of manufacturing, recombinant microorganisms, then DNA sequences whose function is disclosed. All these things were patentable subject matters in case of biotechnology in India. So this is some statistics, which is the graph, which is an old one, and the recent ones were not available. And the graph, initial graph, bar graph, is about up to about 2003, in which the number of patents in biotechnology were listed, and very few when we compare, as we discussed earlier, compared with the European countries and especially America. Our contribution in the patent sector and commercialization of the patent, the number of patents doesn't matter, because maybe you got a patent and maybe there is no use. If there is no use or application or technology developed based on that patent, then there is no point in that one. But in our nation, maybe we have some amount of patents in the recent years, but the actual application or the transfer of the technology into the commercial sector is minimal. So this is a status in the previous years, and in the line graph that is shown on the bottom left, there is a status from 2012 to 2017 is given, and the number of patent applications filed is that much higher compared to the previous years. Recently, in India also, we have a strict patent regulations were implemented, and people, even the researchers, were more and more promoted for obtaining patents and obtaining protection. So that's why nowadays, in the last 8 years, we have a significant growth in the number of patent applications filed. And especially in the case of biotechnology area, we have pharmaceutical products, which is contributing to 55% of the patents that is filed. And industrial process about 41%, and agriculture related patents will be minimal, that is about 4% in case of biotechnology. So this is the general status of patents in the India in the recent years. So this is another one. It's an old one. The graph is about up to 2003 only. Different types of materials like proteins and enzymes were patented 30%, bacteria and bacillus 10%, then vaccines 5%, DNA sequences 5%, transgenic plants or animals, that is 2%. So these are the previous status for the patent applications in India. That's an old one, so it's not a current one, and it is better when you consider the biotechnology. This is a recent one. This is about the patentability or patent status in the patent application status in India in the recent years. Now, this is also an old slide about is up to 2003. The major players were some American companies like American Cyanamide company, which filed 25%, which got 25 patents at the time. That's 2003. Then our CSIR, entire CSIR, that funding agency, our national, the Scientific and Industrial Research Funding Agency, they got about 202 patents at the time. So we can see there are multinational companies, Novo Nordisk or Pfizer, which is a pharmaceutical company, SmithKline Beecham, on the various Hoffmann La Roche. So such different companies got different number of patents, like Hoffmann for 36, Novo Nordisk 79, Pfizer 21. So different companies in the pharmaceutical or biological or biotechnology sector filed different number of patents in these years. So nowadays we can see that the number of patents, if you consider total number of patents, will not be this much. It will be much higher because in the recent years there is a hike in the patent applications. Accordingly, a lot of number of patents were available, but I didn't have the data of that one. So this is a some microbe-related patents in India. We have about 600 patents listed there, and the patent number is given on the right side panel. A process for the isolation and acclimation of bacteria for lignin degradation. Then the titles were given. Some of the examples were there. Beverages containing lactic acid bacteria, modification of bacteria, expression and antimicrobial peptide via the plastic genome to control phytopathogenic fungi, phytopathogenic bacteria. So there are a lot of patents related to the to microorganisms which is granted in India, more than 600. And these are the gene-related patents in India, about more than 146. This is also an older slide, about 2003 status is there. But the total number is different. You can't say that it is now 200 or 600 and 146. It will be a much higher number. But I just want to show you that these items, sub-patent, the microorganisms and the gene patents were nowadays granted and in significant numbers in India also. So these are the patentable subject matters in biotechnology in India nowadays. So this is it. Any doubts?